What's up, guys? Brian Felfel, Law Group PLLC here with your Florida Law Weekly Case Update. Hope everybody's having a great week. We have the annual Family Law Conference in Orlando coming up later this week, so hopefully I'll see some of you guys there. All right, let's get right to the cases. First one is Bronner versus Longden, and this case establishes the real need to be certain when you're putting somebody's name, when you're putting a father's name on a birth certificate, you really got to make sure he is the father, because he will become the legal father in Florida if the voluntary acknowledgement of paternity is not rescinded within those 60 days. And by signing the birth certificate, Florida law provides that the hospital records pretty much require that it be either acknowledged with a notary or essentially under penalties of perjury. So it qualifies to establish legal paternity for that father who's listed on the birth certificate. So that's what happened here. Father was listed on the birth certificate. Apparently he is not the biological father. So it's sort of a convoluted procedural posture, but there were two different cases, one filed by the biological dad, one filed by the legal father. And suffice it to say that the trial court erroneously dismissed the legal father's petition for essentially parental responsibility, time sharing, things like that. The trial court ordered a DNA test, which apparently the father did not file a petition for writ of cert to challenge it, which he probably could have and may have been successful, but he didn't challenge it. And so DNA testing was ordered, and turns out the legal father is not the biological father. So that's known. But that doesn't matter, because he is the legal father, and the law provides that he is for sure the legal father unless somebody can prove fraud, duress, coercion, or material mistake of fact, things like that. It's not good enough to say, hey, too bad you're not the biological father. That's not good enough to essentially disestablish his paternity. He is the legal father. So super, super important. If you're going to put somebody's name on the birth certificate, you got to make sure he's the father that you want the child to have, because it's going to be really hard to challenge it otherwise. Next case is Cancel versus Cancel. Interesting last name. This has to do with pension benefits. So this is a reminder, I guess, for everybody and for trial courts. And there's multiple ways that you can equitably distribute a pension. So you don't have to necessarily have the present value of the pension with actuaries or accountants testifying, expert testimony. You would probably need that if you're going to equitably distribute the present value, the actual present value of the pension. But you could do, and that's the immediate offset method. You could also do the deferred distribution method, which basically says you see what is the value of the payments as of today's date. If the person who has the pension would retire as of the date of the trial without penalty, how much money would he get? And then you take that and then you multiply that by the percentage that the other spouse would be entitled to. So if it's fully marital, maybe 50%, depending on how much of the pension is actually marital. You multiply that percentage or that fraction times the amount that the person would receive if he retired today without penalty, and that is the amount that the other spouse will get from anything that the retired spouse receives upon retirement. So it's sort of like they'll get the future percentage of the future actual payments, not an immediate present value, but future they'll be entitled to receive essentially a percentage. That's the deferred distribution method. So the trial court here, I guess, didn't really know about that. And so the trial court said, well, the parties didn't present evidence of present value of the pension, so I'm just not gonna equitably distribute it. So that was error. Next case is Oria versus Velastegui. This is out of the third DCA. This is a paternity case, and so this has to do with the default. So this is a post-judgment supplemental petition to modify. And so basically what happened here, this is a paternity case. The parties were living together when they had the paternity action, they had a parenting plan that they filed, but the parties were living together. But the parenting plan specifically said, if the parties are no longer residing together, this is what the time sharing will be. Now, it did not provide holidays or school recess time sharing. It didn't provide for communication methods. It didn't have a lot of the things, tax deductions, who would get the tax deduction, multiple things that a normal parenting plan that professional lawyers would include these type of things, and even in the Florida Supreme Court parenting plan, they would include these kind of things. So they didn't have that, but they did have a time sharing schedule, and so they end up splitting up and not residing together, and so the father filed a petition to modify, supplemental petition to modify. Mom did not respond, so father got a default against the father, and so the father's like, hey, I got a default, I get everything that I want. Well, the trial court said, not so fast, my friend, because the parenting plan, the father was trying to establish basically a holiday time-sharing schedule, but the trial court said, nope, not so fast. The actual parenting plan that you guys signed already had time-sharing. It didn't necessarily have to have holiday time-sharing. There's nothing in the statute that says must have holiday time-sharing. So they basically would continue their regular time-sharing during the holidays. They wouldn't have any differentiation. And so the trial court said, even though there's a default, I still don't have to award you that, because based solely on the pleadings, which the parenting plan was attached to the pleadings, based solely on the pleadings, there's no basis for a modification, because it was obviously contemplated what the time sharing would be. You have time sharing in the parenting plan. So the father was not able to modify that. Next case is Bonsignori versus Boulay. This is an interesting case that had to do with, these were two ladies that got married and got divorced, and basically they were the subject of a lawsuit. So during the divorce proceedings, there was this note payable that they owed to, I guess, one of their business partners who loaned them money during the marriage, right? And so during the divorce proceedings, litigation was still ongoing regarding that note. And so trial court was like, what do we do with that? So essentially the trial court basically didn't touch that loan and didn't distribute it either way, kind of just left it alone because of the ongoing litigation. So what happens later, the litigation ends. Apparently one of the wives decided to get a consent judgment, and the other wife, I think, continued to fight the lawsuit, and so her judgment was for a little bit more. And so I guess she was upset because she had to pay a little bit more, and she was arguing. So she was arguing to the divorce court later on in a Rule 12.540B5 motion that the divorce judgment is no longer equitable because of this new judgments against them in the civil case regarding the note payable. I said, look, if I would have known that I would have had to pay all this money for this note payable, this judgment is no longer equitable. It can't be enforced against me. This is going to mess up the whole equitable distribution of all of our assets. And so trial court and the appellate court said not good enough, because in order to have a real good motion under 12.540B5, where you're saying the judgment is no longer equitable, you need to show and allege facts, subsequent facts, that make it no longer equitable. And so here, again, it's sort of like it was contemplated. It was known that there was this potential judgment against them. There was known that they owed this money. And so it's not something new, some new facts that happened after the judgment that make this no longer equitable. So the wife was not able to set aside the judgment under 12.540. Not a new fact that happened afterwards that would allow her to do that. So, but be careful, because I think, practice tip, maybe somebody should have filed maybe like a motion to stay the divorce pending the litigation of that judgment, something along those lines, just so they would know, they would have clarity potentially if this is a really large liability, marital liability, because you may want to have that adjudicated in your divorce. So maybe some sort of motion to stay or abate or something like that could have been filed, but it wasn't. So too bad, too sad. Last case is Pardes versus Pardes. This is a third DCA case. And this one was interesting to me because it has to do with when somebody agrees to a private judge. Super interesting. I don't really think about this very often in my cases. Maybe I should. Arbitration generally, if there's child-related issues, if there's child support, time sharing, things like that, parental responsibility, you can't have any arbitration. You can't have an arbitration of your divorce, and you can't have an arbitration of any post-judgment issues. But that's not the case if there's no children's issues. So if there's no children's issues, you could agree to have a private judge, which is what these people did, Stan Blake. They agreed to have a private judge decide, I guess, essentially their entire divorce. And so what was at issue here was the private judge adjudicated entitlement to attorney's fees, but not amount, reserved on amount. And the trial court thought that because the parties did not specifically agree to have the private judge deal with the amount of attorney's fees to be awarded, that the trial court still had jurisdiction to determine the amount, not the private judge. And so somebody filed a petition for a writ of prohibition to prohibit the trial judge from exercising jurisdiction over this, and it was granted. The third DCA granted to say, look, it's part and parcel of the same thing. And they use the logic of when you're doing an appeal and you get awarded entitlement to fees but not amount, they go together, right? You can't, in other words, it's not a final order if you don't get the amount of fees. So they go together, entitlement and amount. So because the parties allowed the private judge to rule on entitlement to fees, the private judge also rules on the amount of fees to be awarded. So something super interesting to keep in mind in some, especially in cases that maybe involve celebrities or high net worth people or something like that. You may want to consider having and there's no children's issues. If there's no children's issues, you may want to consider having a private judge or an arbitrator make the decision, and maybe even the whole case, maybe even the whole divorce case. So, all right, guys, take care, everybody. Have safe travels up to Orlando. See you there. Bye.